Hello everyone, welcome back to RR Corporates. Now we are discussing section 185 and 186 of Companies Act 2013, loans, investments and compliance, explained in detail. Confused about loans to directors, subsidiaries or investment limits under the Companies Act 2013. So in this video, we are answering 15 complex questions under section 185 and 186 in simplified Q&A format covering principal business activity, LLPs, mutual funds, directors, relatives. So can LLP fall under the ambit of section 185 for the purpose of loan restrictions? The answer is, while section 185 mentions firm, it does not explicitly define it. However, certain references in the Act and allied laws equate firms with LLPs. Since LLPs are considered body corporates under the LLP Act, they can, under section 185 subsection 1 or 185 subsection 2 will depend on the context, especially given lack of judicial clarity. So LLPs may fall within the scope under certain interpretations, especially if directors are partners in the LLP. Second question, can a company invest in mutual funds without triggering section 186 restrictions? Investments in mutual funds are generally not covered under section 186, as mutual funds are structured as a trust and not body corporates. However, approval under section 179 of the Act by the board is still mandatory. Is the term person under section 186 limited to individuals only? The answer is no. Although the explanation under section 186 subsection 2 excludes employees, the term person must be understood as defined under the General Clauses Act, which includes companies, firms, and associations, unless the context restricts its scope. Next question, can a company extend loans to its managing director's relative who is also its employee? Answer is yes, provided the loan is part of the uniform employee policy or approved scheme applicable to all employees. However, if the MD's relative is not an employee, such loan would violate section 185 subsection 1. What if a director is interested in a resolution under section 186 subsection 5? Can the board still pass it? In such cases, the resolution must receive unanimous approval from all non-interested directors present at the meeting, as the interested director must abstain from voting. How do we interpret default under section 186 subsection 5? Though not defined, default generally means default is a failure to meet financial obligations like loan repayments. It implies lapse in fulfilling contractual or statutory duties. Next question, is giving of advances also restricted under section 185? Answer is, if the advance resembles a loan in substance and purpose, it will attract section 185. However, genuine business advances, example for travel or procurement, may not qualify. Can a company give loans to directors of its subsidiary? Section 185 1A does not prohibit giving loans to directors of subsidiary companies. However, general governance and commercial prudence must be followed. What qualifies as a principal business activity under section 185 subsection 3? Answer is, while not explicitly defined, principal business activity typically refers to the core revenue generating operation. Factors include the object loss of MOA, turnover patterns, capital expenditure, and annual return disclosures. Can a company grant loans to subsidiary for activities other than its main business? Answer is no. Loans under Section 185, 3C and D must strictly be used for the subsidiary's principal business activities. Can a company have more than 2 layers of subsidiaries? Yes, provided such companies are not investment companies and they comply with Rule 2, Sub-Rule 2 of Companies Restriction on Number of Layers Rules 2017. What happens if loan is given to someone who later becomes a director? Section 185 applies at the time of granting loan. If a person becomes a director after the loan is granted, then it won't attract Section 185 violations. Are profits in the P&L account considered free reserves for the 186 limits? Yes. If the surplus is available for dividend distribution, it can be treated as a free reserves, even though not separately classified as such under the Act. Is the approval limit under Section 186 subsection 2 revolving in nature? Answer: that depends on how the board resolution is drafted. If it allows for revolving limit, then repaid loans can refresh the limit. If the resolution mentions a fixed sum, the limit does not reset post repayment. Depends on the board resolution how it is drafted. Is investment made in a proposed only one subsidiary exempt under Section 186 subsection 3? Answer is yes. If the intent is to form a wholly owned subsidiary and the parent subscribes 100% to the MOA, such investment qualifies for exemption under Section 186 subsection 3, even if technically the status of WOA starts post incorporation. Thank you. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest updates. Thank you.